this is CACS Tejal Katariya, and with lots of energy, we are going to start with today's session. Today, we will be revising one of the most important unit from Indian Contract Act, that is unit number 5, Bridge of Performance. You will get 5-mark question or maybe 4-mark question from that particular unit. We will try to revise whatever is important from your examination perspective, plus whatever will be like 3-star question, 2-star questions will be there. We will be revising all those questions also. So understand, I have summarized it in max to max 3 pages, the entire unit in 3 pages. You will get the link of these notes in the description box. Go and check it out. In the description box, I have given the playlist of all the revision lectures also. But this is specifically for all those students who are from who needs English everything, the entire video in the English language. So yes, for them, this is unit number 5, that is Bridge of Contract and its remedies. So understand, first of all, with the starting first word, what do you mean by Bridge of Contract? Bridge is nothing but the failure of the parties to perform a contract. Okay, so one of the party is not able to perform, or either it will be actual bridge or it will be an anticipatory bridge. So understand, what do you mean by actual bridge? Actual bridge is nothing but one of the party fails or refuses to perform his or her promise, or expressly or impliedly. Now understand, I'm not explaining this, but I'll just focus on these terms first. Fails to or refuses to perform the contract. Fails to or refuses to perform the contract. Now understand, first of all, fails to means what? For example, if you have ordered 100 kgs of sugar bags from XYZ person, and that XYZ person fails to produce the 100 kgs of sugars, and he fails to deliver it to you. That means he is not refusing it, but he just fails to deliver it to you. That means what? He has done the actual breach because he fails to perform his contract. And the another way is to refuse straight away. Straight away he will refuse either by express or by implied actions. For example, if you have let's take an example. If you have ordered 100 kgs of sugars, on the due date he will be saying that I won't be able to deliver it, your whatever the order is there, I won't be able to deliver. That means what? He refuses to perform. So either it will be one of the party will fail, or one of the party will refuse to perform his or her promise, either by express ways or by implied ways. Implied is nothing but by some course of action he will imply. Okay, now understand, this actual breach can be on the due date or during the performance of the contract. On the due date means what? If the due date is say, let's take an example of 14th of Feb. Let's take an example of 14th of Feb is your due date, and on due date someone is saying no to you. That means is nothing but what? This is the actual breach on the due date. Okay, and the second thing is either it will be or it will be a during the performance of the contract. During the performance of the contract means what? Let's take an example that you're supposed to pay 10 installments of rupees 10,000 each. 10 installment of rupees 10,000 each. You paid 1, 2, 3, 4 installments, and 5th installment you did not pay. Now this is nothing but what? During the performance of the contract. That means what? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. During this performance, you have done some breach. This is nothing but during the performance of the contract. So either it will be during or it will be on the due date, but obviously you are going to breach the contract. That will be the actual breach of contract. And the second type is anticipatory breach. You may get question on this. You have similar, what you can say, similar kind of questions in your RTPs, MTPs, or even the exercise which is given below your modules or below your units of all the Indian Contract Act. Okay, so go through the questions first, and then only you will get to know how you will get the question on anticipatory breach. So anticipatory breach is nothing but when one of the party declares his intention of not performing, or signifies his unwillingness, even before the time of performance arrived. even before the time of performance arrived, either expressed by words spoken or written, or by implied ways, that means by the conduct of the parties. Now understand, anticipatory breach is nothing but what? It's not an actual breach, it's an anticipatory. Anticipatory means you are predicting that this contract, one of the party will not form the contract. So let's take an example that if ABC, let's take an example XYZ and ABC. Okay, ABC decided to sell his car. Okay, this is car. Assume this is a car. Okay, this is a car. This car XYZ decided to sell it to ABC for rupees 10 lakh on maybe 14th of Feb. Assume 14th of Feb. Now what happens on 10th of Feb? On 10th of Feb, XYZ sell this car to LMN. Now this is nothing but what? This is implied way to show the unwillingness, to signify the unwillingness of the one of the party. This is nothing but the anticipatory breach. Okay, this is nothing but anticipatory. Why? Because the due date is yet to arrive, but before due date only, because of implied course of action, implied way, or by the conduct of the parties, you get to know that this contract, one of the party may refuse to perform the contract. Okay, or either he will directly expressly say that I don't want to perform the contract. So anticipatory is nothing but what? This is kind of contract where you have done the contract today, you are going to perform it in the future, but before the due date arrives, you breach the contract, or any of the party breach the contract. Effect of this is quite important, given under section 39. Section 39 says that if there is anticipatory breach, then you have two options. As an aggrieved party, you have two options. One of the option is either treat the contract as rescinded and sue for the damages without waiting for the due date. That means without waiting for the 14th of Feb, you directly on the 10th of Feb itself, you directly resign the contract and can claim for the damages, or you elect to not to resign the contract and to wait until its due date is coming, or until the 14th of Feb. Okay, so there are two ways: either you resign immediately on the default and you can claim for the damages, or you wait till the due date. This is nothing but what? Effect of the anticipatory breach. That is nothing but given under section number 39. Remember section number 39, it's quite important from your examination perspective. Okay, the next very important section from the Indian Contract Act is section number 73. Now understand section number 73, you will get the lot of information about the damages in your module, but I have summarized it in such a way that you will get to know very quickly that what kind of question you will get in the about the damages or on the section number 73, and the second thing, what you supposed to write in your exam. So these are the 4 key lines which you remember forever. I mean till the time you pass the exam. The section number 73 talks about the first. It talks about the damages. So first, breach of contract. The party who suffers from the breach. This is nothing but the aggrieved party. This is nothing but who? Aggrieved party who suffers from the breach, entitled to receive the compensation for any of the loss or damages from the another party. Correct? So the person who have suffered the loss is entitled to receive the compensation from the party who defaults in the performance of the contract. Now these damages or the compensation is nothing but what? For any of the loss or damages which naturally arise in the usual course of event or the usual course of business. So understand, damages is nothing but where you naturally this is nothing but not kind of a punishable thing. It's naturally arises because of the default in the contract. But these damages are original damages, or you usually get these kind of damages, but there are certain other types of damages also. One of the type is nothing but special damages, in which you will get the special damages only on the previous notice only. If you have given the another party the previous notice, or the promisee of the previous notice that in case of default this much of the damages I'll be claiming for, or some kind of this thing, then you can say that there is a special damages. And the last is no compensation is payable for any of the remote or indirect loss. Now understand, This line is quite important. No compensation is payable for any of the damages for any of the remote or indirect loss. Question is given in your MTP1, MTP1 for given under given for June 2023 attempt. So in MTP1 you will get the first question itself about that Himalaya travel, something kind of a question is there. You will get the link of that MTP1 video also in the description box. Go and check it out, because that this line is very important from that question's perspective, which you may get in your exam. So in that no one will pay for any of the indirect loss or any of the remote losses. They are just require the aggrieved part, the party who makes the who breach the contract are only or only what you can say should give only the damages, either a special damage or the original damages, but they are not responsible for any of the indirect loss or remote losses. Okay, so this is all about section number 73. But for section number 73, we supposed to discuss more in detail about the ordinary damages and special damages. The ordinary damages are nothing but what? The loss which naturally arose in the usual course of a thing. This is nothing but original, and special you supposed to give the notice to the previous notice should be there. Now understand, I'll give you the example for this. You will get the similar example just by replacing the number or the name of the parties in your exam. So please focus on this example. Let's take an example that there is a Mr. A and the another party is Mr. B. Mr. A and Mr. B has done a contract of delivering the 1000 of bottles at rupees 5 each. Delivering 1000 of bottles at rupees 5 each. Let's assume this is a bottle at rupees 5 each. They are going to deliver it on a let's take an example on the 1st of June. Let's take an example. Okay, on the 1st of June 2023 they are going to deliver it. Now this bottle is nothing but of water bottle. We are not going to talk about any other kind of bottles. So please do not mistaken. Here we have only water in it, nothing else than that. I hope so you understand. This is nothing but the water bottle we are talking about. Now let's go ahead. So there is a contract between A and B. Okay, now because A want to deliver 1000 bottles at rupees 5 each to Mr. B on 1st of June, he is doing another contract with Mr. C, that is doing another contract with Mr. C for 1000 bottles only, but at 4.5 rupees. But at 4.5 rupees each, or the per bottle. Now understand, C is going to give it to A 1000 bottle, and then A going to give it to B. Correct? You understood? C is going to receive 1000 bottles from A is going to receive 1000 bottles from C at rupees 4.5, and he is going to deliver it to the B at rupees 5. That means 0.5 paisa will be his profit or commission or whatever. Correct? This much is clear. Now understand, C did not perform the contract. C did not perform the contract. Now how much damages A should ask from C? Now the question is, how much damages A can claim from C? This is the question. Here you will get two types of answer. Okay, here you will get two types of answers. The first will be C is aware of the contract between A and B. First of all, he is aware. C is aware of the contract between A and B. And here C is not aware. Okay, so we have two situations where C is aware and C is not aware. If the C is aware, what will happen? He will claim. He can claim. He means who? A can claim. A can claim 4.5 rupees minus 4.5 into 1000. Whatever the loss he suffered, that means 0.5 into 1000, that means 500 rupees of loss. Why only 500? Because he was aware and He was having the previous notice that A has already contracted with B. So understand, this is nothing but what? Where C was aware, that means he was having a previous notice, that means this is nothing but the special damages. This is nothing but what? Special damages. Where C was already aware, C was having the notice that A want to perform the further contract. If he makes a default, A is also going to make a default with B. Okay, now if the C is not aware, so in a natural course of business, how much damages A can claim from C is nothing but, see, understand, this will be the market price minus their contracted price into 1000. That means this is nothing but 0.75 into 1000, so 750 rupees he can claim for. Why? Because it has arrived in the natural course of business, natural course of event. This is nothing but the original kind of a damages. This is nothing but the special damages. What happens usually, student, because the word is special damages, student feels that special is nothing but over and above original first thing. This is also wrong. And the second, they believe that special damages should always be greater than the original damages. This is not the case. Understand. Always understand that original damages is different, or special is different. Original is nothing but where in the natural course of business you will get the money. Here you will get the market price, whatever market price minus the contract price. You will get this much of loss. Okay, you will get this much of damages in the ordinary course of business. And if the C is aware, then you will get only that much of damages, because he is already having the previous notice. A is not going to sell it in the market, but he is going to sell to the B, and that's why he will get only and only 5 minus 4.5, that is nothing but 0.5 rupees as a loss, or the of loss as a damages. I hope you understand this. Special damages and you can say original damages. You take a screenshot or you write this example, you will get similar kind of example, just replacing the numbers and replacing the party's name. So please understand, this question is quite important from your examination perspective. So first of all, kinds of damages. First is ordinary damages and the second is special damages. So here in ordinary damages, you already have one of the case law, similar case law of crankshaft, if you guys remember, calling Handley versus Bexdell. You just go through that case law also. Whenever you get the question on original damage, you're supposed to write this case law for sure in your exam. Don't write the entire facts of the case of this Handley case, otherwise you will not get the marks. So you just supposed to give the reference or the name of the case law you're supposed to mention in your exam. I've already told you how you should be writing paper, case study based questions, or maybe the straightforward questions, how you're supposed to present your paper. I have discussed everything during our lecture. If you still have a doubt, you can ask me either in the comment section of this video. Please do like, share, subscribe. You don't like only, you just get the knowledge and you leave. So this is not right also, correct? So please do like, share, subscribe this particular entire knowledge or the channel's detail. Now we will be discussing special damages. We have already discussed actually. Special damages is nothing but where you give the previous notice already of the sale, so you will get only special damages. Now the third type of damages are vindictive or exemplary damages. Two types of damages are covered, two types of scenarios are covered in these damages. Vindictive, one is wherever you do not marry with somebody and you hurt someone's feeling, and the second is in case of check dishonor because of reputation loss, you claim this damages. Try to write exact language whatever is given in your module in the paper. Don't write only hurting someone's feeling and dishonor of check for any reputation loss. Don't write only these 2-3 words. Try to write the whatever is given in your module. Try to use that language. The next is nominal damages. Nominal damages is nothing but 0.10 paisa, 0.5 paisa. Nominal means nominal, very nominal value you will ask for. The next type of damages is damages for deterioration caused by delay. This is nothing but what? Deterioration caused by delay is nothing but what? Deterioration is nothing but the decrease in the value or the decrease in some quality, correct? So deterioration caused because of the delay. This delay does not only include the physical damages but also the loss of opportunity. Now understand, this is quite important, that see, deterioration usually happens in case of perishable nature goods. Okay, so if you are asking, if you have ordered some fruits, let's take an example of Kashmiri apples. Okay, you have ordered the Kashmiri apples from Kashmir, and because of the delay, you get the apples after 7 days maybe. So the quality of those apples have already reduced or have already deteriorated. So now you understand, if you are going to sell these in the market, already you are going to get the less value. So you can claim for the damages for this. Because of this delay, you can claim for the damages also, along with the, not only that physically damaged goods, but also kind of a also for the loss of opportunity, that you are going to sell it in the into the market. So all that loss of opportunity also you can claim. So you can claim for the damages for that also. So damages for the deterioration caused by delay. So these are the 1 2 3 4 5 damages. Along with that, the last damages is quite important damages, that is nothing but prefixed damages given under section number 74. You will get one of the question either on 73 or on 74. So or one of the remedies which are given in your unit number 5. So these are the three questions. If you haven't studied only unit number 5, please try at least you cover section number 73, 74 and one of the remedies which I'll be telling you whenever we will be discussing that. So please remember these three type of question you may get from unit number 5. So the understand prefix damages given under section number 74. Here you will get the long paragraphs all about the liquidated damages and penalty. So basically the liquidated damages is nothing but the fair or the genuine damages which you have pre-estimated for any of the loss due to the breach, and then you claim for that. And penalty is quite something which is which is quite disproportionate with your contract value, or which is so exorbitantly high that your contract value is even lesser than what is the value of your penalty. So exorbitantly high amount is nothing but penalty, but the genuine damages or genuine loss which if you are recovering, that is called as liquidated damages. Here the intention for liquidated damages is just for the recovery, and here to ensure penalty is something where you try to penalize somebody. You just try to, what you can say, threaten somebody by imposing by including that clause of penalty, so that other party will perform the contract. So to make sure that other party will perform the contract, for that matter you will be having penalty in your clause. So these are the two things. So you may get a question on liquidated damages versus penalty differentiation. There are 5 points given in your module. Other than that, the entire paragraph don't try to read right now. It's just a summary. I have summarized this in these 2 points, that differentiation. They are repeating again and again and again same these points in all those 5 points. So try to just at least go through these 2 points once. So if you get a question on differentiation, I have given it, but understand according to the Indian laws there is no such differentiation. That means if in case of breach of contract, you will get the penalty or whatever the reasonable loss, whichever is lower. That means if you in your contract you have claimed that you will be getting the penalty of 50 lakh, any of the party who will any of the defaulting party will pay the another or the aggrieved party worth rupees 50 lakhs as a penalty, where your contract value was only for 5 lakh, you are claiming the penalty of rupees 50 lakh. So understand, in this situation Indian laws do not penalize in such a higher way. Indian law says if whatever the reasonable loss or penalty, whatever is lower, we will claim for that. So so here it's quite what you can say given in a very clear manner that liquidated damage is nothing but where you have mentioned this in case of breach you will pay certain sum of money as a damages, but the penalty is something where you have stipulated in such a way that you want to punish somebody. Now here the complaining party, that means the aggrieved party, can get the compensation, but reasonable compensation which shall not be exceeding so amount of the liquidated damages or penalty. Whatever is lower, you will get that. Reasonable damages you will get. You will not be getting like so exorbitantly high amount where your contract value is hardly something. So please understand. So here you will get only one question. Prefix damages is first of all, you will get one question on prefix damages. If what will happen if in your contract there are prefix damages. So penalty or liquidated damages, whichever is lower, you will get in case of breach. The second thing you will get on this is differentiation between liquidated damages and penalty, which is already given in your module also, and I have also included this in our notes. And the last point from unit number 5 is remedies for the breach. Up till now we just go through what kind of a breach is there, what are the kinds of damages you will get against that. Now what are the remedies you are available with you in case any of the party makes a default. The first point is nothing but rescission of a contract. Rescission is nothing but cancellation of the contract, and you can claim for you will entitle for the damages. Who will entitle? Aggrieved party. The second is quite important. You may get a question on quantum merit. Okay, quantum merit is nothing but, according to my language, is as much as you have earned. As much as you have earned means what? You're supposed to compensate only to compensate for the value of the work done and not in the entire whole value. That means there should be two conditions which should be there. First, only available if the original this quantum merit is only available if the original work has been discharged, and the second, claim must be brought by the party who is not in default. That means the person who is not in default, that means aggrieved party, is claiming for compensation and claiming for that compensation where original work has not been completed or has been discharged. Now understand, for example for this. So these are kind of a quantum merit is nothing but what, that you should be paying to the another party only for as much as you have earned. For example, this is your house. Okay, this is your house, and what happens is some painter is painting your house. Okay, some painter is painting your house. This is the brush. Assume that this is a brush and this painter is painting your house. What happened is, this painter painted this much of your house, and the remaining part, this much part of your house, and the remaining part you don't allow him to paint. Okay, you don't allow him to paint, but he have painted this much of your house. Now what will happen? As much as you have earned means what? You're supposed to compensate to this painter for this much of the part of your house. Understand? You should not enrich yourself at the cost of others, what we say. That means what? That if you are taking benefit from any of the contract, you should compensate or you should pay for that as much as you have earned, that much as much as you have earned, or as much benefit as you have taken. Okay, so this is very, very simple. What we do in our real life also we should apply here. Like, these damages should be are like compensatory in nature and not the merit of restitution. Restitutory means what? Well, quantum merit is restitutory means nothing but the restoration of the benefits basically. So what are the cases in which you will be applying quantum merit? The first, where the agreement becomes void. Let's take an example of alcohol. You have ordered, let's assume that X person, not you, you are a minor, so X person have ordered 100 bottles of alcohol. Now today, now this is nothing but the alcohol. So this is alcohol, 100 bottles of alcohol you have ordered. The party Y person have sent 50 bottles. Y person have sent you 50 bottles and 50 is still pending. Afterwards, what happens is, government of UP maybe, or any of the government ban alcohol. Government banned this alcohol, selling, manufacturing, producing, reselling, everything. Government banned alcohol altogether. Now you have taken the benefit of 50 bottles. Even though 50 is pending, you have taken the benefit of 50 bottles. But because government banned, your contract becomes void. your contract becomes void because your object becomes unlawful. So that's why your contract becomes void. And in this situation, if your contract becomes void, but because you have taken the advantage or the benefit for those 50 bottles which Y sent you, you supposed to pay, you means X supposed to pay to the Y for all those 50 bottles. This is nothing but quantum merit. So the first is agreement, when agreement becomes void. The second is something, someone has done something without any gratuitous intention. Gratuitous is nothing but someone has done without the intention of volunteering. Means what? With the expectation of getting something. In that situation, if someone is not giving you any of the voluntary services, obviously you supposed to pay for it. The third is expressly or impliedly mentioned in the contract. In that situation, one of the party refused to perform the contract. If one of the party, I have given the example of this painter, one of the party, that means the owner of this house, it refused to perform, restore him or restrained him from performing his contract, then obviously as much as he has earned, that party supposed to pay. The next is when the contract is divisible. That means you can divide the things, like 50 bottles, 100 bottles, you can divide the things. So you can claim for 50 bottles, don't claim for remaining 50 bottles which you haven't received yet. So whenever the contract is divisible, obviously as much as you have earned, you're supposed to pay for it. But if what will happen if your contract is kind of indivisible in nature, then whatever the lump sum amount you have decided, or your contract value minus the bad work or whatever the work which is still pending, that much of amount you're supposed to pay in case of indivisible contract. And the last two merits, or the last two remedies which are available with the aggrieved party. The third is suit for specific performance. For example, you have gone to the doctor or any of the dentist, okay, and now after going there, that person, for example, you wanted to do that root canal kind of a thing. So in that, if there are kind of a 4 sittings you're supposed to do. Now after cleaning and everything, when you're supposed to place a cap on that, the dentist decided or refuses to pay, then obviously you won't be like pay me for this, or paid me or give me the compensation for this. For you, the important matter is to place a cap on your tooth, correct? So understand, in this kind of situation, you can claim for the specific performance instead of damages in the monetary terms. So you can claim for suit for specific performance. And the last is suit for injunction. Injunction is nothing but basically the court order. You can get the court's order as well as an aggrieved party. So understand, this is nothing but the unit number 5. This much is very important from your examination perspective. Section 73, 74 and quantum merit. And somewhere you may get, these are kind of a 2-star questions. These 2 points will be kind of a 2-star. Otherwise, other than this, even if you are in very, very bad condition, please just revise section 73, 74 and this, and then only go to your exam. I have already mentioned which you may go through the MTP, RTP questions for this unit also. So there are certain questions, there are few questions in your RTP, MTP. So just go through them. All the best, keep revising. Let me know in a comment section about this lecture, and do like, share, subscribe and share this with everyone. Take care, bye bye, keep revising.